2 years ago, my phone rang. On the other end was a woman I'll call Patricia. She wasn't reaching out about her own situation. She was calling on behalf of her elderly mother, a 78-year-old woman named Ruth, who had spent the past 4.5 decades living in the same home. That home was entirely paid off. There was no outstanding mortgage, no lien, no financial obligation of any kind tied to it. Ruth had spent her final 3 years receiving care at a nursing facility. That care had been funded through Medicaid. The family had navigated the entire process responsibly. They submitted the Medicaid application correctly. They disclosed every relevant piece of information honestly. They followed every instruction they were given. Ruth passed away quietly and peacefully, roughly 6 months before Patricia picked up the phone to call me, and then something unexpected showed up in the mail. Not a sympathy note, not a routine administrative document, a formal legal notice from the state government, informing Ruth's family that the state was moving forward with a claim against Ruth's estate, and specifically targeting her home in order to recoup the cost of the Medicaid-funded care she had received during those 3 years in the nursing facility. The figure the state was seeking to recover from the home Ruth had owned outright for 44 years was $227,000. Patricia was in tears when she called. She said to me, "How can this even happen? My mother owned that house free and clear. She paid it off herself. She intended for us to have it. The government doesn't have the right to just take it." I had to deliver news that I have unfortunately had to deliver to far too many families during far too many conversations exactly like that one. The truth is, yes, under federal law, through a program known as the Medicaid Estate Recovery Program, the state absolutely can do this. And in 2026, with revised state-level recovery regulations expanding the definition of what qualifies as a recoverable asset across multiple states, the financial exposure families face is greater right now than it has ever been before. But that was not the only thing I shared with Patricia. I also told her something important. There are legal strategies, specific, well-documented, and time-sensitive strategies that could have shielded Ruth's home from this exact outcome. These are strategies that Ruth's Medicaid advisor never brought up, strategies that the admissions staff at the nursing home never disclosed, strategies that the state Medicaid office certainly never volunteered on its own, strategies that genuinely work, but only when they are put in place before Medicaid coverage begins, not once it is already underway. In this video, I'm going to walk you through everything Patricia's family needed to know before Ruth ever set foot in that nursing facility. We will cover what the Medicaid Estate Recovery Program actually is, why a fully paid-off home carries significantly more exposure than most families ever realise, the 5 legal protections that are available right now, and exactly what you should be doing if you or a loved one owns a paid-off home, and there is any chance that Medicaid-funded long-term care may be needed down the road before it becomes too late to take meaningful action. This video is for every family that has spent a lifetime working toward owning their home free and clear. Stay with me. Before I take you through the 5 protections, I need you to fully grasp the scope of what the Medicaid Estate Recovery Program actually represents, because the overwhelming majority of people have never heard of it. And the families who encounter it for the first time are almost always finding out about it after the moment when something could have been done to stop it. Here is the federal legislation that brought this program into existence. In 1993, Congress passed the Omnibus Budget Reconciliation Act, commonly referred to as OBRA 1993. Tucked inside that law was a provision that mandated every single state to create and operate a Medicaid Estate Recovery Program. The mechanics of the program work like this. When a Medicaid recipient who received nursing home or long-term care benefits dies, the state is obligated under federal law to pursue recovery from that individual's estate for the cost of the Medicaid services they received. The estate includes everything that person owned at the time of death, and for the vast majority of seniors, the single largest asset in that estate is their home. The program specifically targets Medicaid recipients who are 55 years of age or older at the time they received benefits, which essentially captures every senior who receives nursing home Medicaid coverage, and it applies regardless of how long the person held ownership of the home, or how fully it was paid off, or what their wishes were about passing it on to their family. Here is the figure that makes clear just how significant this program is. According to research from the Kaiser Family Foundation, States collectively bring in approximately $700 million every single year through Medicaid estate recovery efforts. Every dollar of that money is pulled directly from the estates of seniors who genuinely believed their homes were safe and protected assets. Most of those seniors had absolutely no idea the program existed. Most of their families learned about it exactly the way Patricia did, through a piece of mail that arrived sometime after the burial. Here is the specific development in 2026 that makes this more pressing than at any previous point. Several states have revised their Medicaid estate recovery regulations this year, broadening the definition of a recoverable estate to include assets that were previously shielded in certain states, among them particular categories of trusts, joint ownership arrangements, and life estate interests. Protective strategies that were still fully available last year have a narrower window of effectiveness in several states today, and the fully paid off home is the primary target because it carries the most equity, the clearest title, and the most direct and uncomplicated route to recovery from the state's perspective. A home that still carries a mortgage has limited recoverable equity attached to it. A home that is completely free of any mortgage has its entire value sitting open and accessible to a state's recovery claim. If you or someone you care about owns a paid-off home, and there is any real possibility that Medicaid-funded long-term care may be required at some point in the future, understand what I am about to share with you is the most critical legal information you will encounter this entire year. Hit the subscribe button right now. This channel exists specifically to get this kind of information into the hands of families before they need it, not after the notice shows up in their mailbox. Now, let us get into the 5 protections. Protection number 1 is the Irrevocable Medicaid Asset Protection Trust. This is the most thorough and complete protection available, and when it is set up correctly, with adequate lead time, it has the ability to fully shield a paid-off home from Medicaid estate recovery. Here is how this works. An Irrevocable Medicaid Asset Protection Trust, which is sometimes referred to as a MAPT, is a particular type of legal trust into which you transfer ownership of your home. Once your home has been placed into this trust, it is no longer considered part of your estate as a matter of law. In the eyes of Medicaid, you are no longer the property owner. The trust holds ownership, and assets owned by the trust at the time of your passing are generally not subject to the state's Medicaid estate recovery claim because they fall outside the boundaries of your personal estate. You retain the legal right to continue living in the home for the remainder of your life through a specific provision written into the trust agreement. Your children or whichever other individuals you designate are named as beneficiaries of the trust. Your daily life in the home continues exactly as it did before. The meaningful difference is that the property now rests inside a protective legal framework that removes it from Medicaid's reach. Here is the critical element of timing that most families overlook entirely. Medicaid operates under what is referred to as a 5-year look-back period. Any transfer of assets, which includes the act of moving your home into a MAPT, that takes place within 5 years of submitting a Medicaid application, is subject to a penalty period during which Medicaid will refuse to cover benefits. What this means in practical terms is that a MAPT must be created a minimum of 5 years before Medicaid benefits are set to begin in order to provide complete protection. A family that puts a MAPT in place today, before any urgency around Medicaid planning has developed, is in an entirely different and far stronger position than a family that attempts to create one after a nursing home placement has already taken place. Ruth's family had the opportunity to set up a MAPT a decade ago. The home would have been fully protected at that point. The $227,000 recovery claim would never have materialized. The cost of establishing a MAPT through a qualified elder law attorney generally falls somewhere between $2,000 and $4,000, depending on the state and the specific circumstances of the estate, compared to a potential recovery claim of $200,000 or more. The cost-benefit ratio of that investment is among the clearest and most favourable of any form of legal planning that exists. Protection number 2 is the spousal protection exemption. This protection applies specifically to married seniors, and it is the most immediate and most powerful protection available without requiring any advanced planning whatsoever. Under federal Medicaid law, a home is exempt from state recovery as long as a surviving spouse continues to reside in it. This is known as the spousal protection exemption. If a Medicaid recipient passes away and their spouse survives them and remains living in the home, the state is prohibited from pursuing estate recovery against the home for as long as the surviving spouse is alive. This protection is absolute and does not require any formal legal steps to activate. It takes effect automatically through the operation of federal law. But here is where the protection becomes more nuanced and where families repeatedly make errors that end up eliminating it entirely. The spousal exemption provides protection for the home during the lifetime of the surviving spouse. Once the surviving spouse also passes away, the estate recovery clock begins to run again. At that point, the state has the ability to file a claim against the home for the cost of the first spouse's Medicaid benefits, and in many states, for the second spouse's Medicaid costs as well, if they also received coverage. The spousal protection is not a permanent or final solution. It functions as a window, specifically the surviving spouse's lifetime, during which other protective strategies can and absolutely should be put into effect. A surviving spouse who takes no action during that window simply transfers the Medicaid recovery problem to their children without resolution. The appropriate way to use the spousal protection exemption is to treat it as protected time in which to implement one of the other strategies on this list, ideally the MAPT, during the period when recovery has been temporarily deferred. When used together this way, the spousal exemption and a properly timed MAPT can provide complete, multi-generational protection for a paid-off home. Protection number 3 is the caregiver child exemption. This protection is among the least recognised and most valuable exemptions in the entire body of Medicaid estate recovery law, and it applies to a specific set of circumstances that is more frequently present than most families understand. Under federal Medicaid regulations, a home that is transferred to a child of the Medicaid recipient who resided in the home and personally provided care to the recipient for a minimum of 2 years directly before the recipient was institutionalised, and whose care demonstrably delayed the point at which institutionalisation became necessary, is exempt from Medicaid estate recovery. In straightforward language, if an adult child moved into the family home or was already residing there and delivered hands-on care to their parent for at least 2 years before the parent required nursing home placement, the parent can transfer the home to that child without triggering the 5-year Medicaid penalty, and the home is shielded from recovery following the parent's death. This is called the caregiver child exemption, and it carries 3 distinct requirements that must each be satisfied. First, the child must have genuinely lived in the home, not simply visited with regularity, but actually resided there. Second, the caregiving must have continued for at least 2 consecutive years immediately prior to the parent entering a nursing facility, not 2 years at some earlier point, but the 2 years that directly preceded the institutionalisation. Third, the care provided must be supportable through documentation as having delayed the moment when nursing home placement became necessary, meaning medical records, statements from the parent's physician, and other evidence establishing that the parent would have required a nursing facility sooner had the child's in-home caregiving not been provided. When all 3 of these conditions are met, the transfer of the home to the caregiver child is legally protected. The home passes to the child, and Medicaid has no claim against it. For families in which an adult child has been providing in-home care to a parent, this exemption can be the deciding factor between the family home remaining within the family and the state stepping in to recover it. But the documentation must already be in place, and the transfer must be executed properly with the help of an elder law attorney to confirm that every requirement has been fully satisfied. Protection number 4 is the sibling equity exemption. This protection is more limited in scope than the others, but it addresses a specific family situation that is not uncommon. Under federal Medicaid regulations, a home cannot be subject to estate recovery if it is transferred to a sibling of the Medicaid recipient who already holds an equity interest in the home, and who was living in the home for at least 1 year before the Medicaid recipient was admitted to a nursing facility. In plain terms, if a brother or sister of the senior holds any ownership share in the family home and has been living there for at least a full year before the senior moved into a nursing facility, that sibling's portion of the home is protected from estate recovery. Furthermore, the transfer of the senior's share of the home to that sibling can be completed without penalty. This exemption is particularly relevant in family situations where siblings have been sharing a family home, sometimes one inherited from their own parents, and one sibling requires nursing home care, while the other continues to live on the property. The sibling who has maintained residence in the home and holds an equity interest in it can receive the nursing home sibling's share of the property without activating Medicaid estate recovery. If this scenario applies to your family's circumstances, even in part, it is worth sitting down with an elder law attorney to evaluate whether and to what degree the sibling equity exemption provides protection for the home. Protection number 5 is the hardship waiver process. This final protection is the one that becomes relevant when none of the advanced planning strategies were ever put in place, and a family is now sitting across from an active estate recovery claim, which was precisely the position Patricia and her family found themselves in. Every state Medicaid Estate Recovery Program is required under federal law to maintain a hardship waiver process. This process gives the estate or surviving family members the opportunity to apply for a full or partial waiver of the estate recovery claim based on documented evidence of hardship. The specific standards for hardship differ from one state to another, but federal guidelines identify several categories of qualifying hardship that every state must take into consideration. These include situations where the home is the sole income-producing asset in the estate, and recovery would eliminate that income stream. Situations where recovery would render the heirs eligible for public assistance programs themselves. Situations where a dependent family member has been living in the home and would have no other housing option available to them. And situations where the dollar value of the recovery claim represents a disproportionate share of the total estate. There is one critically important thing to understand about hardship waivers. They are not automatic. They are not simple to secure. And in a significant number of states, the waiver application process receives very little public attention or outreach. States carry minimal financial motivation to make waiving recovery claims a straightforward or well-advertised process. But hardship waivers do exist. They have been granted. And an elder law attorney with specific experience handling state recovery cases in your state can meaningfully improve the probability of a successful outcome on a hardship waiver application. Patricia's family ultimately did submit a hardship waiver application. The state agreed to accept a substantially reduced recovery amount, settling for considerably less than the original $227,000 claim after reviewing the documented hardship circumstances the family presented. It was not a complete resolution. Some money did change hands, but it was a dramatically better result than it would have been had the family simply accepted the original claim without mounting any challenge to it. If you are currently dealing with a Medicaid estate recovery claim, do not simply pay it, and do not pretend it does not exist. Reach out to an elder law attorney without delay and ask specifically about the hardship waiver process in your particular state. Let me bring all 5 protections together one final time. The Irrevocable Medicaid Asset Protection Trust is the most complete solution available. It must be established no later than 5 years before Medicaid benefits begin. It typically runs between $2,000 and $4,000 to create, measured against a potential recovery claim that may be 10 to 20 times that amount. The Spousal Protection Exemption is an automatic federal protection that applies during the lifetime of a surviving spouse. Use that protected window to put additional strategies in place. The Caregiver Child Exemption may allow a penalty-free transfer and a full recovery exemption if an adult child lived in the home and delivered documented caregiving for 2 years immediately before institutionalization. The Sibling Equity Exemption may protect a sibling's interest in the home and allow a transfer to that sibling without penalty if the sibling held an equity stake in the property and resided there for at least a year before the senior's institutionalization. And the hardship waiver is available if you are already facing an active state recovery claim. The process exists, it carries real weight, and with the right legal support, it can reduce or completely eliminate the claim. 5 protections. Every single one of them real. Every one of them accessible right now. And not a single one of them mentioned by the Medicaid office, the nursing home admissions department, or the state agency that will eventually draft and mail the recovery letter. Ruth's family had no way to undo what had already occurred. The opportunity for protective planning had closed. But Patricia told me directly, if we had known all of this 5 years earlier, my mother's house would still belong to our family today. That statement is exactly the reason this video was made. Share it with every family you know that owns a paid-off home and has a parent moving into the stage of life where long-term care may eventually become a reality. Because the 5-year look-back period means the time to take action is not when the need presents itself. The time to act is now, a full 5 years before the need ever arrives. The letter Patricia received landed in her mailbox 6 months after her mother's funeral. The legal strategies that would have prevented it from ever being sent needed to have been in place 5 years before Ruth entered that nursing home. You now have that knowledge. Put it to use before the letter finds its way to your door. What happens if Medicaid denies a benefit application because of asset transfers that were made before the 5-year look-back period was properly accounted for? Take a look at the next video, where I break down precisely how to appeal a Medicaid denial and the specific legal arguments that have successfully overturned those denials during administrative hearings. I will see you there.